Okay, I've been out of law school 10 years now, so it's safe to say I'm not necessarily a new lawyer anymore. So I wanted to talk to you guys about top mistakes that new lawyers make. Seen them personally firsthand, so I'm going to share them with you so that hopefully you don't make the same ones. Let's talk about it. So if you're new to the channel, we talk about pre-law, law school, and beyond. And this really focuses on the beyond part, right? You go to law school, you take the bar exam, and now that you're out there practicing, what mistakes do you want to try to avoid? So I wish I had it with me, but every month I'm part of the Texas Bar Association. They put out a bar journal, and in it, there are a list of people who have disciplinary actions, whether they are getting disbarred or whether they have some kind of suspension, something, because they violated some rule of professional responsibility that you have as an attorney. So when you're in law school, you take probably professional responsibility as a course, and then you have to take the MPRE. And people are like, oh, this is just like fluff. No, it can really get you in trouble later if you don't follow certain rules. And it really is enforced once you're in practice. And I'm going to talk about some of the top tips that you can do to avoid some of these problems. Some of you that may be working at law firms may have paralegals or administrative staff to help you manage certain things. But let's say you're a solo practitioner or you work in the government where you may not have as much support staff. Some of these things may impact you because you are responsible for certain things, certain filing deadlines, certain receipt of funds, things of that nature. So one of the top things is make sure you don't miss any filing deadlines. I know that says it goes without saying. People still do it, and what it could do, it can cost your client a whole case. If you watch my other video, I did a time management video. That kind of goes hand in hand with it, because when you take on a case, you have to pay attention to what the filing deadlines are and make sure that you file any extensions if you need extensions, but you have to know what those deadlines are in order to file an extension. What the worst thing is to have to go back to a client after you've accepted a client, to go back and tell them that because of your inability to manage deadlines, you didn't file their case on time, and now they don't have any case. Sometimes there's statutory limits on when you have to file something. There's no exceptions to it, right? So you want to be careful about how accept the cases, and also be careful about how you calendar them in however you keep your calendar, on your phone or a paper calendar. You don't want to have that hard conversation, because what will end up happening is the client will get upset because you missed the deadline that prevented them from being able to file this case, and they'll sue you for malpractice. Now, that's something that you don't want to have to go up against, defending the fact that you were negligent in filing the case. So I see that happen a lot, where clients are upset because you missed the deadline. Now, there are certain exceptions or rules. Sometimes you can file exceptions to say, can I have extension because I need time to do this if you show good cause. But you have to know that the deadline is coming upon you to be able to file an extension to it. It can't happen already, and then you're like, oops, let me try to go back in time. So keep that in mind. Like I said, if you're working at some law firms, they have paralegals that kind of keep abreast of what the deadlines are for you. But in the event, you also kind of just want to know for yourself, because at the end of the day, the paralegal is not having a bar license. You have the bar license, and you don't want to lose it. I know people were so celebratory when they passed the bar. I would hate for you to have to get suspended or lose your bar license because you did something that was not in line with the professional responsibility of a lawyer. Okay, here's one that you might think is not a big deal, but it can affect your client in the long term. So let's say you are representing a client and you're giving a document by the opposing counsel, and you read over and tell the client, you just sign it, it's okay. And then you miss out on an important piece of information that negatively impacts the client. You think it's that reading is fundamental, right? And sometimes it not just happens with new lawyers. Old lawyers get kind of cocky too. They're like, oh, I know that's standard, boilerplate. Just go ahead and sign it, and not making sure that you went through it and made sure that, you understood what the client was signing. The client is relying on you to provide information to them. And if they rely on you and rely to their detriment, and you have them sign something that they, wouldn't have agreed to, then that's something, again, the client is going to end up, if they have enough time, suing you over malpractice because they said, I didn't agree to this. And it has to kind of be something that really negatively impacts them. And so you want to make sure you read everything that opposing counsel or anything that is pertinent, that before you get the client to sign it, you read it, make sure you understand it, and make sure the client understands what they're reading it before they sign it and before it's filed or before it's sent back to the opposing counsel. Okay, the next one is like a 2-4. And comment below if you have any other things that you kind of encountered. If you're a new lawyer, you're like, oh, I made that mistake. Y'all watch out for this. Comment below so that you can share with other new lawyers as well. So the next one is like a 2-4. So what we see happen is that the lawyer doesn't effectively communicate with clients. So the client is like, I haven't heard from my attorney in weeks. I don't know what's going on. Whenever they feel like they're not being heard, that's when they go file bar complaints against you. So you want to make sure you effectively communicate. Granted, it doesn't mean that you have to always, every time they send you a email that maybe not even be important, say something lengthy, but at least acknowledge, like, I received your email. We will address this at a later date. If you want to get all your questions together at one time and we can address it all together, that'll make time more efficient. Something that makes them feel heard. Because the worst thing a client can do is feel unheard. And then, like I said, they go and make a bar complaint against you. The next one goes also to co-mingling funds. So you put the funds that you receive from a settlement into an account that's not the client, the client account is actually mixed in with your personal account. And when you get audited, or you try to produce the funds later, there's no account of like, this money was from this money's from the client, this is my personal money. Co-mingling funds is one of the main reasons I see people in the Texas Bar Journal get disciplinary actions for, because you never want to mix the funds. You take out whatever you need for your, let's say, is retainer, or take out whatever your percentage is for whatever the settlement is, and you have it in a separate account that does not mix up with anything else, so that you can't, when the client says, no, I was supposed to give this amount, and you only gave me this amount, you have a clear accounting of what's going on. So communicate with the client and don't commingle funds. Okay, so this last one, I observed it if you watch my other video, I did a judicial clerkship for 2 years on a criminal calendar. And I saw this, and it's funny, even as a new lawyer, I recognized when certain pleadings were good and when they weren't, when they were wasting the court's time and they weren't. And another mistake that some new lawyers make is not conceding facts. Like, they want to argue all the facts. And sometimes both sides say, okay, we agree, this happened, this happened, this happened. This part is where we disagree, right? But new lawyers sometimes want to just be in there arguing. That's not good for judicial economy. Judges do not like that. As like I said, I work with a judge, and he despises when people could not agree. Like, we don't dispute this. No point of wasting time for witness testimony or evidence submission over something that we agree on, right? What don't we agree on is what we're here for today, right? And I think that new lawyers, they're, so eager to kind of show off their skills that they forget, like, show your skills off for the relevant parts of this case. And sometimes, you can get certain things out the way. And judges actually prefer that, and they will possibly look more favorably upon you if you are helping them get to the crux of the matter. And so if you watch my other videos about law school, teach about brevity, sometimes brevity is best, especially in legal pleadings. When you're actually in cases and doing preliminary hearings and things of that nature, the judges appreciate brevity in the sense that you like, Judge, I talked to, let's say, the government and defense counsel. We agree upon these. We're going to go forward with this. The judge is like, thank you. This is what we're going to be talking about today. So keep that in mind. If you have any other comments or questions about other topics we should discuss, go ahead and put them in the comments section below. Sometimes we post little polls on our community tab, so check those out, and we'll see you in the next video.